Hello everyone, welcome to NDA Defence Institute CAPF AC previous year question solving series. In this video, we will be seeing the Polity CAPF 2022 question papers, the questions. Let's go to the video. The first question, which one of the following statement is not true with regard to the tribal welfare? Yes, so if you see here, they have given lot of statements like the comprehensive tribal development program aims at land development, improvement of roof, infrastructure development. Yes, it is right. It is another scheme under Ministry of Tribal Affairs. Second, as per the Scheduled Tribes and Other Traditional Forest Dwellers Act, yes, so this is also called Forest Dwellers Act. Villages in the forest are provided community rights. Yes, for example, the scheduled tribal people, they can collect this MFP, minor forest produce, like honey, wood and all. These are called minor forest produce. They have the customary or community rights. Only the ST people can go and get things in their forest. They are allowed. Other people are not allowed. So it is yes. So it is also right. Second statement. Third, the Special Area Development Program aims at distribution of forest area produces to the tribal equitably. Exactly, it is also there. But you see D is the incorrect one. Why? You see the Special Assistance, Central Assistance to Tribal Subplan provides dairy cows to tribal people living below the poverty line. No, it has no such schemes like tribal dairy cows of tribal groups and all. So this D is incorrect. So the Ministry of Tribal Affairs has lot of schemes under its aegis. For example, it is implementing this MG Narega scheme, Mahatma Gandhi National Rural Employment Guarantee Act, this scheme, then Vandan Yojana, National Bamboo Mission, the Northeast region, to commercialize this bamboo, National Bamboo Mission, and also this PM, the recent one is PM Q11 Yojana. Yes, this PM Q11 Yojana is under this Ministry of Tribal Affairs. It talks about the second generation bioethanol production. Bioethanol. This ethanol is this ethanol blending in petrol will happen. So that is what the government is having a target. So blending the petrol with ethanol. Yes, so the 2G bioethanol production from biomass and crop residues. So this scheme is under this PM Q11 Yojana. Yes, so this PM Q11 Yojana is under the Ministry of Tribal Affairs. So a lot of such schemes are there as of now. Out of this, the answer is D, because they are asking for not correct. D is not correct. So it has nothing to do with giving dairy cows. Second question, when was the Kothari Commission appointed by the Government of India to look into education sector of India? Yes, the Kothari Commission was appointed in 1964. Yes, it is one such very important committee after we got independence. Before that, lot of committees are there during the British line, like Macaulay Bennett, Hartog Committee, Hunter Committee, Surgeon Plan, Woods Dispatch, lot of those committees are there. But after the independence, this Kothari Committee is the first major committee appointed by the Government of India. It also includes Indian members and delegates from other countries also. It is appointed in 1964 and it talked about the revamp of this new educational policy. Recently also the National Education Policy NEP has been going on rounds. This NEP, the chairman of that committee is Dr. Kasturi Rangan. So the chairman of the New Education Policy, National New Education Policy is Dr. Kasturi Rangan committee. This committee headed by Dr. Kasturi Rangan only, they only gave all the points, they only gave all the salient features of this new education policy. Yes. So here the answer is D, 1964. Next one, the landmark case of DC Wadhwa versus State of Bihar, 1987. Yes, in Supreme Court is related to which of the following powers to the governor they are asking. If at all you see it, the answer is A, to repromulgate ordinances. So what is this DC Wadhwa case? Simple. We all know both the governor and president has ordinance. For example, the president has ordinance power. Same the governor also has ordinance power with respect to the state law. President has ordinance power under Article 143. Yes, under Article 123. That is the ordinance power of president. Which means that if the parliament is not session, if either Lok Sabha or Rajya Sabha, if either both are not in session or one is in session, another one is not in session. If you cannot able to pass a normal law by parliament, or if you cannot able to pass a normal law in the state legislature, then an emergency law can be passed by the executive. That is called ordinance. So ordinance is a temporary law. It is a temporary law. It is just a coextensive power. It is not a parallel power of legislation. it is given only during emergency situation, because if at all you need a law immediately, but you cannot able to assemble all the parliament MPs, and if you cannot able to assemble the MLAs immediately, but overnight we need a law, so the ordinance can be passed, but after that the ordinance has to be approved by the houses. That's why the maximum life of ordinance, maximum life of an ordinance is 6 months plus 6 weeks, because the 6 months is the maximum gap between 2 sessions, and 6 weeks once the assembly started, within 6 weeks you have to approve the ordinance, or else it will automatically expire. The ordinance will automatically expire. Yes. So that's all about this ordinance. This what happened later, to bypass this parliamentary passage, what happened, to bypass the state legislature passing bill, the executive, the governor and the CM plus C1, they started to pass laws as an ordinance, so that what happened, the ordinance has to be put into the when the session is started. So within 6 weeks the ordinance cannot able to be approved, and after 6 weeks the ordinance will lapse. Again after the prorogation of the session, again the executive will pass the same ordinance. So in this DC Vadva case only they said, if at all you are without changing the content or text of a bill, and you are passing the same bill again and again by means of ordinance, then that is considered to be unconstitutional. Those ordinance can be removed. So this only gave a restriction. So this put a speed breaker along the way in which the executive is using the ordinance power. So it is related to this ordinance. So repromulgate means passing the same ordinance again and again. So as of now you cannot pass the same ordinance again and again to bypass the parliament or state legislature passing. So this case is related to this ordinance. So answer is A. Next question. Which one of the following is not a feature of Indian federalism? So we all know Indian federalism is also called quasi-federalism, because we are neither federal nor unitary. Federal means pakka division of power between the center and state. For example, a classic example of this federal country is USA, where state has a strict powers, whereas federal government also has strict power. But in India, if you see, India both unitary feature, where central government is powerful, it is also there, and India also have federal features, where state will also be having power. Both the things are there. That is why India is a quasi-federal country. So in this context, they are giving an option. You see, courts can interpret the constitution and powers of the different levels of the government. Exactly, that's the job of judiciary. Whenever the federal provisions has been touched, the state and center will come to the Supreme Court only to solve the dispute. So the Supreme Court will take up the case in its original jurisdiction. Second, the source of the revenue for the union government and the state governments are specified. Exactly, in the center-state relationship, they are clearly mentioned from what are the sources from which the both union and state can generate revenue. It is also given. So B is also the right one. C, powers of the union and states are specified in the constitution. Exactly, the 7th schedule of the constitution. The 7th schedule talks about 3 lists. What are the 3 lists? Union list, state list, concurrent list. So this 3 list has been provided. So this clearly defines in what is the power of union, what are the matters in which the union can pass law, what are the matters in which state can pass law, and what are the matters where both state as well as the union can pass law. So the 7th schedule clearly divide the power. So this is the division of power between the center and state. So yes, C is also right. They are asking for not correct one. So obviously it is D. Why? Indian federalism is based on principle of separation of power. No. Indian federalism is based on principle of division of power. Division of power. So central government will be having some power. It will be divided between the center and state. So division of power is there. Indian federalism is not based on separation of power. Whereas you go to USA, the USA's federalism is based on separation of power. So there legislature works separately and then this executive works separately. But in India it is division of power and not separation of power. So D is the wrong one. They are asking for not correct. So D is the answer. Next question. Which of the following is our source of law in India? You look at it. First is Constitution of India. Second is statutes. Third customary law. Fourth case law. All are sources of law in our country. The Constitution of India, this is the main source. We can say this is the Magna Carta, or very important document. Yes, statute means nothing but law. Law is also called statute. So law is also part of the sources of law. Customary law, we follow certain things as a convention and tradition. That also comes under that. and case law, where certain things has been promulgated or defined by some cases by the courts, interpreted by the courts, both Supreme Court and High Court. All these are the sources of law. They are just asking sources of law. If at all they ask what is the main source of law, then that is only one, Constitution of India. But generally they are asking what is source of law. All comes under the source of law. So the answer is D, 1, 2, 3 and 4. Next question. Which among the following is our functions of the Cabinet Secretariat? Yes. So what is a Cabinet Secretariat? Simple. If you see, the executives at the central level is Prime Minister plus Council of Ministers. Yes. So imagine this is the Council of Ministers. At the center there will be a nucleus of this Council of Ministers. That is nothing but Cabinet. This Cabinet is a very important or high powered decision making body. In fact, this is a supreme decision making body. Yes, this is called the nucleus of the government. Nucleus of government. Some important ministers, high level senior and important ministers will be there, including the Prime Minister. This Cabinet will be having a bureaucrat. That bureaucrat is nothing but Cabinet Secretary. Mostly this Cabinet Secretary will be a IAS officer. So what is the Cabinet Secretary job? They are asking. You see, to ensure interministerial coordination, exactly, that is the job of Cabinet Ministry. In fact, the Cabinet Secretariat will convey what is the decision of the Cabinet to each and every ministry, and if that all there is any rubbing or if there are any miscommunication between the ministry, they will act as a coordination or a cohesion point. So yes, that's a job. First one is right. It ensures coordination between different ministries. Second, management of major crisis situation in the country. If at all urgently or some very important decision is needed immediately, the Cabinet will conclude, the Cabinet will come and assemble, and then the Cabinet Secretary will actually brief the issue to the ministers like Prime Minister and other ministers. They only will take the decision. So it is a major crisis. Even during COVID time, lot of time the Cabinet came together, and then the Cabinet Secretary is the one, the Cabinet Secretariat along with the Cabinet Secretary is the one who actually coordinated all the health related issue during the pandemic period. So both are answers. Both 1 and 2 are right. They are asking for the correct answer. The answer is C, both 1 and 2. Second one. Which are the following statements about the Committee on Public Undertakings is correct? We all know this. There are 3 standing permanent standing committees of Parliament. One is Committee on Public Undertaking. Second is Public Accounts Committee, PAC, and the third one Estimates Committee, EC. So these are the 3 permanent standing committees. They are asking about this public undertakings. So you see the first one. There are more members from the Rajya Sabha than the Lok Sabha in the committee. If you look at it, the total number of members in the public undertaking is 22. 15 are from Lok Sabha, LS, and then 7 are from Rajya Sabha, RS. So total it is 22 members. But you see here there are more members from the Rajya Sabha than the Lok Sabha. No, it is wrong. There are more members in the Lok Sabha than the Rajya Sabha. That is the right statement. First statement is wrong. You see the second one. The chairperson of the committee is appointed by the Speaker of Lok Sabha. Exactly. All the 3 committee chairmen, Public Undertakings, Public Account Committee, Estimate Committee, all the 3 committees chairmen are appointed by the actual Speaker of Lok Sabha himself. So second is right. They are asking for the correct answer. The answer is B, 2 only. Next one. Which of the following statement is not correct with respect to censure motion and no confidence motion? We have to know what is censure motion, and no confidence motion. No confidence motion. So simple. These are 2 parliamentary procedural devices or mechanisms by which the legislature will have control over the executive. Yes, MPs can have the control over the ministers. For example, censure is simple. It is like giving a warning to the ministries, like PM plus COM, Prime Minister plus Council of Ministers. They are the executive. So censure, it can be given either to the Prime Minister or either to any particular minister, individual minister, or a minister as whole, or a PM plus COM as a whole, because it is just a warning. But no confidence motion, it is to prove that because generally we know in the parliamentary form of government, whoever has majority, the majority party leader in the Lok Sabha can form the government. They can able to form the government. So if the other party members think that the PM plus COM has lost the majority, then they can move this non-confidence motion. If at all it is passed, then they have to resign. If the non-confidence motion is passed, if passed, they have to resign, because it openly proves that the PM lost the majority, the party lost the majority in the Lok Sabha. That is why this non-confidence motion can be passed only against the entire Council of Ministers, not to the individual ministers. So in this context, let's go to the statement. A censure motion can be moved against a single minister of the Council of Ministers. Exactly, because I told you censure motion is just a warning. You can warn any individual minister. If the finance minister is not working properly, you can just pass a censure motion and censure the finance minister, ask him or her to do their work properly. Yes, it is possible, it is right. You see the second one. A motion of no confidence cannot be moved against the Prime Minister alone. Exactly, because the no confidence motion can be moved only on entire Council of Ministers, COM, including the Prime Minister. So PM plus COM together only you can move no confidence motion. Yes, the 2 is also right. You see the D option. A censure motion can be moved against a group of ministers. Yes, you can. You can move against individual, you can move against group also. Yes, it is also right. So this is left with the C option. They are asking for not correct. Obviously C is also not correct. And you go to the statement now. A censure motion cannot be moved against the entire Council of Ministers. No, it can be. Warning can be either issued to individual persons or to the whole group also, because it is just a warning. But no confidence motion, you cannot do it to the individual minister. You have to do for the entire Council of Ministers as a whole, PM plus COM as a whole. So this is wrong. Here it is not cannot be, it is actually can be. So C is the wrong answer. No, wrong option. They are asking for not correct. The answer is C. Next one. Which of the following is correct in respect of appointment of district judges? Yes, the district judges according to the constitution are appointed by governor in consultation with the High Court of the concerned state. High Court of concerned state. If the Madras High Court, if in Tamil Nadu, they are appointing a district judge in Tamil Nadu, then governor has to appoint along with the Madras High Court concerned state. Yes. So with this context, if you see, only option C is the answer. You see, they are appointed by the governor in consultation with the High Court of the concerned state. So this is for district judge. For other judges, other than the district judge, for other judges, again the same. Governor has to appoint, governor plus High Court of the concerned state, High Court of the state, plus also that concerned State Public Service Commission, SPSC. For example, if at all in Tamil Nadu, it is TNPC. So the TNPC has to conduct an exam, recruitment drive. They have to conduct an exam. After that, they have to recommend the names. Then the governor will appoint, asking for the permission of, asking the consent of the High Court of that particular state. This is for other judges. When I say other judges, any judges other than district judge are called other judge. So yes, here C is the answer. Next one. The Swaran Singh Committee recommended the insertion of which of the following provisions into Constitution of India? Yes, Sardar Swaran Singh Committee. Sardar Swaran Singh Committee is responsible for adding fundamental duties in our Constitution. Original Constitution does not have fundamental duties. The 42nd Amendment, 42nd CAA, Constitutional Amendment Act 1976, added Part 4A and Article 51A. That is nothing but fundamental duty. Sardar Swaran Singh Committee recommended 10 fundamental duties. Yes, no, it occurred 8 fundamental duties. 8 fundamental duties, but later the government has given 10 fundamental duties. So here it is B, fundamental duty, a direct question. Next, what is the term of office of chairperson and members of National Human Rights Commission, NHRC? This NHRC is a statutory body or a legal body which is created by means of an act. Legal body, yes. Initially, before when it was created in 1993. When it was created, the Protection of Civil Rights Act, the actual duration is 5 years or 70 years. 5 or 70 years. But what happened because of that? Okay, they cannot able to drive a lot of, they cannot able to get lot of, generally the chairperson and members can be retired Supreme Court judge or a High Court judge. Since maximum age of High Court judges, Supreme Court judges is 65 years, they cannot able to get proper recruitment. So that is why they passed this, Protection of Civil Rights or NHRC, National Human Rights Amendment Act 2019. This 2019 Act amended the tenure or amended the year minimum qualification year for the judges, and that says 3 years or up to 70 years of age. So instead of 5 years, now the age limit for chairperson members is 3 years or 70 years, whichever earlier. So it is B, answer 3 years or 70 years of age. Yes. Yes, so with this, the 2022 questions are done. Thank you for watching this video. If at all you need more videos like this, log on to our website. Take care. Thank you.